In the second part of the lesson, that is court judgments, we will be seeing what is happening from the month of March, because March 1969, because what is happening after Justice Chinnapareddy's verdict, now there is a question mark put on the GO number 36. GO number 36, which is very crucial, the first product of 1969 movement. GO number 36 was made by the government to satisfy the Telangana agitation, to support MULKI issue, to give employment. And now with Justice Chinnapareddy's verdict, the whole GO number 36 is becoming a questionable thing. Along with GO number 36, MULKI rules are also becoming questioning, even the extension. So what is happening? Again, we have come back to square one. So in this background, what will happen? Once the judgment is in favor of non-MULKIs, then some people are going to Supreme Court to get the stay on the transfers which was already ordered. The state government was ordering or issued orders to transfer non-MULKIs to their native places, replacing them from Telangana region. So when they are being asked to leave Telangana or getting transferred or removing, so automatically when the GO number 36 is questioned, though they are going to the court and getting the stay on this GO number 36. So GO number 36 was questioned on 17 February 1969. Supreme Court stayed the implementation of GO number 36. Supreme Court stayed, and this case was filed by AVS Narasimha Rao, that is an appellant, and 7 others. They went to the court against the government of AP. As we have seen, Justice Chinnapareddy's verdict came on 3rd February and this is 17th February. So AP government stayed the process of transfers based on the Supreme Court stay. AP government under Kasu Brahmanand Reddy need a pretext to halt all the things which they are promulgating, which they are starting to satisfy Telangana agitation. So automatically the Supreme Court said stay on the transfers. So they have stayed. On 19th February they have issued an order to stay the transfers as Supreme Court said. Now next, again interesting, this is like ups and downs in Telangana movement. Court judgments are very, very interesting. And the next judgment, the first 2 judgments as we have seen are not in favor of Telangana people, not in favor of MULKI rules. But the next judgment, that is High Court's division bench, is quashing Justice Chinnapareddy's verdict. High Court division bench, once the verdict of Chinnapareddy came, then again appealed into the High Court division bench, so that we will be discussing is it valid or not, because it is a single judge bench. Now it is division bench of 2 people, Justice Pingali Jaganmohan Reddy and second one is Justice Justice P. Jaganmohan Reddy, that is Pingali Jaganmohan Reddy, and the second one is Justice Avula Sambashiva Rao. So Jaganmohan Reddy Avula Sambashiva Rao bench, this bench has said that Chinnapareddy verdict is not correct. So they have quashed, means they struck off Chinnapareddy's verdict on 30th April 1969. The 134 page verdict, their verdict was 134 page, and this 134 page verdict has clearly said that the Act of 1957, that is rules of 1959 and the Act of 1964 which was extended, all are constitutional. This constitutional validity given to the MULKI rules is again putting some life in the MULKI issue, because when you question the original concept of MULKI itself in the Chinnapareddy verdict, as we have seen, Kuppuswamy verdict is concerned with APSEB, but Chinnapareddy verdict is all encompassing. They are talking about the Act, talking about the rules, talking about the GO. Now division bench quashes Chinnapreddy verdict and favors MULKI issue. So this MULKI issue has again come to up, means MULKIs are favorable, MULKIs are favored. This was very important. And again, when the verdict of this division bench came, AP government has approached the Supreme Court for the vacation of the stay. As we have seen, the Supreme Court has issued a stay order on implementation of GO number 36. Then automatically the process is you have to approach the Supreme Court to remove the stay order on GO number 36, because the division bench said it is constitutional. So you can transfer the non-mulkis. So when the AP government approached the Supreme Court, again a new thing has come up in MULKI issue. That is, the Supreme Court full bench said MULKI rules are unconstitutional. Very interesting again. Now it is individual court judgments, then comes High Court division bench, means two people. Then comes Supreme Court. In Supreme Court, it is the full bench. Supreme Court is supreme than High Court. Now the Supreme Court's judgment is very, very important, and it is supporting non-mulkis. On 28 March 1969, full bench of Supreme Court chaired or headed by Justice M. Hidayatullah and members J.C. Shah, V. Ramaswamy, G.K. Mittar and A.K. Grover, A.N. Grover. All these people, the five-member bench, that is Supreme Court full bench, said MULKI rules to be part of the state is not constitutional. Means they are saying that once you have a state in formation, all the rules should be equal to the state. You cannot have a different set of rules or some safeguards or some special encouragement to one particular region in a state. That is what the Supreme Court full bench is saying. So they have quashed the MULKI Act. Once they have quashed the act, the rules will also go. Once the act is gone, rules is nothing but the implementation of the act. Remember about this legality. Once the act is formed, immediately again the government and the law department has to form the rules to implement it. Nitty-gritty of the act means how to implement, who is the appellant authority, who is the authority, where to do, what is the jurisdiction, what are the legal terms. All these things should be interpreted in the rules so that there will be no ambiguity, no confusion, no misrepresentation. So act and rules go together. This judgment of Supreme Court full bench quashed MULKI Act and rules, and finally GO number 36-2. So what has happened? Again we came back to the first phase where we are not finding any solace with the court. Telangana Mulkis are not finding solace. In between, another thing is happening, that is Vanchu committee. So when we are talking about this Supreme Court full bench verdict, that is Hidayatullah's verdict, Justice Hidayatullah headed committee's bench verdict, which was declared on 28 March 1969. In the month of July, we have, in the month of April, we have 8-point formula. 8-point formula is very important. That is declared by Indira Gandhi. Indira Gandhi is declaring 8-point formula at a time where the whole Telangana movement was at its peak. Lot of activities are going on, and 8-point formula was declared to satisfy this agitation. Remember, Indira Gandhi, as always, no for Telangana. She was never supportive for the Telangana issue. Why? Because she doesn't want any internal disturbance, as already there was a political disturbance inside the party, inside the government. This is a crucial juncture the Indian state was going, Indian government was going in. Inside the Congress party also, Indira Gandhi was facing opposition. And 70s is crucial period. You have many things are happening internationally. 71, you have Indo-Bangla war. We are getting closer to Russia. In this background, Indira Gandhi is preoccupied with international and Indian events or national political events, and she never wanted to, what you call, in Telugu we call it as Tene Tuttanu Kadapadam, means you shouldn't disturb the honeycomb. Once you disturb the honeycomb, it will sting. Formation of a state is a honeycomb. This was the understanding. And she was adamant. And you can't fight and take from Indira Gandhi. She is such an iron lady, and she was not ready to accept or heed to the demands of any agitation. So finally what has happened? Because Indira Gandhi was adamant in that sense not to grant Telangana a separate state, she will come up with different set of formulas. We will talk about this when we are discussing about 8-point or 5-point or 6-point of Indira Gandhi. The psychology of Indira Gandhi when she is bringing these formulas. So, as part of the 8-point formula, a committee was formed which is known as Vanchu Committee, which is discussing about the Mulki issue. Vanchu Committee is the expert legal committee chaired by Justice Kailasnath Vanchu to look into Mulki issue. So, the 8-point formula says we will look into the constitutional legal aspects of Mulki issue, and a committee of experts will look into. So, Vanchu Committee came. This Vanchu Committee gave its report in August 1969, and it is again what you call not in favorable of Telangana. It is also depressing for Telangana. What it said was, Mulki rules, clause 3 of Article 17, for implementation of the Mulki rules, clause 3 of Article 17 has to be amended. Then, if you have to amend, what are the hurdles? Already there was a judgment known as Golaknath case. And in Golaknath case, the Supreme Court said it is not possible to amend in such a way. So, Golaknath case has taken as the precedent, and Vanchu Committee said, if we want to make some provisions, legal provisions to amend the law, amend the Article 17, that is clause 3, then Golaknath's case will not allow it. The verdict in the Golaknath case will not allow it. So automatically what happened? Vanchu Committee has said that to provide employment for Telangana people, you cannot have a constitutional thing or a thing which is central. So they have provided some measures like make the subordinate employment completely local. Local means it is not state level. You make the employment of subordinate level in the district or exact local level. There you need not go for constitutional amendment. You can have your own say when you are doing at a local level. Either TRC, Telangana Regional Committee can look after into the employment at the local level. So he suggested that go for local level and you cannot have a constitutional provision for Mulki, because Golaknath case was the major thing which is a hurdle. He cites it. Remember in your examination, you may get which case is related to, which among the following cases is related to the Mulki rules or Mulki judgments during this period. That is Golaknath case. So, the bench came with a verdict that Mulki rules are unconstitutional. Then Vanchu Committee says Mulki rules cannot be made as a constitutional thing. You cannot bring the credibility, or you cannot make the Mulki rules constitutional because of this. Then comes the another verdict, that is High Court full bench said Mulki rule constitutional. Mulki rules are constitutional. High Court bench of 3 members, that is headed by Chief Justice Kumarayya and Justice Gopalrao Egbote. The third one is Justice E. A. Sambashivarao, pronounced a judgment on 9th December 1970. 9th December 1970, and said that Mulki rules are constitutional as per Article 35B of Indian Constitution. That is what I said in the beginning. Understanding a verdict needs what was the thing the judge or the bench or the appellant or the advocate is interpreting. Now they have interpreted Article 35B of Indian Constitution and said Mulki rules are constitutional. And this is High Court bench. Do you think High Court is it is superior than Supreme Court? Supreme Court full bench said it is unconstitutional. Now High Court full bench says it is constitutional. In this case, it is not overriding the powers of Supreme Court, but they have merely taken the question of Article 35B. And they said Section 3 is gone because of the Supreme Court verdict. When you remove Section 3, automatically Section 2 will also go. So what will happen? Mulki rules of pre-57 will be continuing. This Section 3 or Section 2 interpretation is being done with reference to the Act of 1957, AP Employment Act. So once the Section 2 or 3 are gone, now what is happening? The Mulki rules of pre-1957 should be continued and Mulki rules are constitutional. This is the major aspect they were talking about. So again, now to sum up about this verdict, full bench is in support of Mulki rules. Then comes the last verdict, that is last but one verdict, that is High Court full bench. The other one is High Court full bench is saying Mulki rules are constitutional. Then another High Court full bench is saying that Mulki rules are unconstitutional, because it is not the discussion on the Mulki rules, it is the discussion of the appellant's aspects or some points of reference the court will be commenting upon. So once the High Court full bench said Mulki rules are constitutional, another High Court full bench says Mulki rules are unconstitutional. The case is related to Venkat Reddy versus AP government. This Venkat Reddy was an employee in the state government, in the industries department. He and some other people were recruited and they were given training as extension officers. But because of the Mulki rules at the GO number 36, all the happenings of this time, some people were retrenched, some people were demoted to a lesser post. So we, Venkat Reddy and some other people are going to the court. In this case, in this appeal, Justice Obul Reddy, Kondayya, Konda Madhav Reddy, ADV Reddy, Sri Ramulu, all these are justices. All these justices means 5 justice bench, that is High Court full bench, is saying that this Mulki rules are void, unconstitutional. But it is not an unanimous judgment. It was the majority verdict. Majority verdict means 4:1. 4 people said Mulki rules are not constitutional. One person, one justice differed with the 4 and gave a minority verdict, because minority verdict is not to be implemented, but the verdict will be recorded. So minority verdict by justice, who we can guess among Justice Obul Reddy, Kondayya, Konda Madhav Reddy, ADV Reddy, Sri Ramulu. It is Justice Konda Madhav Reddy who was giving the other opinion other than the 4 justices. So these 4 people were giving one judgment, and the other one, Justice Konda Madhav Reddy, said Mulki rules are constitutional. But as the verdict goes with the majority, now Mulki rules became unconstitutional again in the High Court. Then the then Chief Minister P.V. Narasimha Rao, he knows the gravity of the moment. P.V. Narasimha Rao, as critics have difference of opinion about his role in globalization or something, or P.V. Narasimha Rao's political acumen is so sharp, but administration, there are some people who said he couldn't control Andhra Pradesh. But it was a crucial juncture when the agitation was so intense, and when the things are going out of the hands, Andhra leadership or Andhra movements are coming up against P.V. Narasimha Rao, accusing him of bias. So P.V. Narasimha Rao government appealed to Supreme Court after this High Court full bench said Mulki rules are unconstitutional. And the last verdict, which is very, very prominent and important, which has put a full stop for all the arguments in this period in the courts of law, that is the verdict of Supreme Court full bench, which says Mulki rules are constitutional. Mulki rules are constitutional. So the final verdict of this phase is very, very clear. It says Mulki rules are constitutional. On 3rd October 1972, Chief Justice S.M. Sikri, Justice A.N. Ray, Justice Y.D. Duva, Justice D.G. Palekar and H.M. Beg. All these 1, 2, 3, 4, 5. These 5 people, that is Sikri, Ray, Duva, Palekar and Beg. This bench, this full bench declared that Mulki rules are constitutional and said the clause, the number of years designated as in the Hyderabad state, that is 15 years of residence introduced by Nizam rule or Nizam government, is still valid. The validity, the constitutional validity of Nizam's rule of 15 years of permanence was upheld, was accepted, was made constitutionally valid by the Supreme Court full bench. This says Article 371 was amended for the benefit of Telangana. When you amended the Article 371 for Telangana, so automatically you have to provide things, and Mulki rules is one such provision. So the essence of Supreme Court full bench I am talking about. This bench agreed with the High Court full bench verdict, which said Mulki Act is constitutional. We have seen that High Court full bench, Kumaraya's bench, which said it's constitutional. It agreed with that and said they have quoted in their verdict some of the points points written by Justice Konda Madhava Reddy favoring Mulki rules. So this bench has mentioned that the political and constitutional background for the continuation of Mulki Act should be understood whenever we want to talk about this one. So constitutional validity of Mulki rules can be studied, can be understood only if we understand the political and historical background of the merger. So Mulki rules should be implemented. This is the verdict. And as a result, P.V. Narasimha Rao, the then Chief Minister, was very happy. He welcomed the judgment. He welcomed the judgment as if as it is going to resolve many issues, because once the court gives a verdict, automatically it will have its impact on the society. The validity is counted. So this is the full bench verdict under Justice Sikri. So remember the names of the judges or benches and headed by. These are the questions you can expect in your examination. So what are the things happening in this entire period? If you want to understand, if you want to sum up, if you want to come to some generalization, the first aspect, as I said in the beginning of court judgments itself, is the points of reference in any court or in any appeal is very, very important. Point of reference means what? What are you arguing for? Are you arguing for a small issue, or you are arguing about the generality of the act? Sometimes the court judgments are pronounced, though it is taking the minute aspect, one specific aspect, it comments upon the broader aspect of the act. Like when you talk about APSCB, the first judgment is related to APSCB only. They are not giving much of the wider scope. The Justice Alladi Kuppuswamy is not giving a wider scope to his judgment. But when it comes to Vobal Reddy's judgment, Justice O. Chinnapareddy's judgment, it is very, very clear that Justice Chinnapareddy's judgment is coming to a phase where you are commenting upon not just a simple issue of GO number 36, you are talking about the broadest aspects of it. So to conclude, since January 1969 till the last verdict of Supreme Court in 1972, majority of the court judgments were not in favor of Telangana. Whether it is local single bench, single judge bench or Supreme Court full bench. It impacted upon the Telangana movement. Sometimes we got what you call disgruntled, sometimes we get depressed, and sometimes we got a boost. So, some of the verdicts did not take the historical background of the Mulki rules. As a result, they are looking at mechanically about the constitution or the country as a unit or a state as a unit and saying that you can't have a set of rules for the state, for a region in a state. It is discrimination they are saying. But they are not taking into the account that historical and constitutional background when you are making an act. So, the last point about the summing up is the judgments which are not in favor of Telangana were definitely acting as a detonating thing or a stimulant to go for protesting or go on protest to continue the agitation and demand a separate Telangana state. Because in the United Andhra Pradesh, if the rules are not in favor of Mulkis, that is Telanganites, so staying in Telangana, staying in United Andhra Pradesh is not possible because we may not get jobs. This strong understanding in Telanganites is very important, and as a result, whenever you have a judgment against Mulki rules, it will become a precursor for the movement or a stimulant or a detonating thing for the movement. See, it is the employment which is ultimately we need. If you see, whenever there is a favorable thing for Telangana, the movement could be happy and could fight for the right. But when the last judgment was pronounced by the Supreme Court saying that these Mulki rules are constitutional, Andhra people went into agitation. Jayandhra movement came. Jayandhra movement is a result of the court judgment. Court said Andhras are non-locals in Telangana, so they can't take an employment, take a job in Telangana. Then they asked for separate Andhra state. Till then Telangana was asking. You can see a very clear difference. Unless, if you have the employment, you will not fight for the statehood. At least this is one of the reasons. And Telanganites were asking for employment, they did not provide. The United Andhra Pradesh did not provide, so they went on agitation in 1969. But in 1973, when High Court said, Supreme Court said, Andhras are non-locals and they may not be favored in employment in Telangana region, immediately Jayandhra movement came and they said they want a separate Andhra state. You can see the logic behind it. So, to sum up the court cases or judgments, what we say is, court judgments is an important chapter which interprets the aspect of Mulki in Telangana issue.